great state of Florida, and this honorable court.
Thank you. You may be seated. Good morning and welcome to the First District Court of Appeal. We have one case on our OA docket this morning, case number 25-765, Palmetto Surety Corporation versus State of Florida. Counsel, when you're ready.
Yes, thank you, Your Honor. Your Honor's counsel, may it please the court. I'm here on behalf of Palmetto Surety Corporation on an appeal from a denial of a motion to set aside a final judgment of a bond forfeiture under statute 903-27, actually under 903-27 subsection 5. While not considered the most well-known statute, it's a very important statute in terms of the business of bail bond agents, and it helps along with review of 903-26. They sort of go hand in hand in their sequential statutes. 903-26 feeds into 903-27 under certain circumstances. So it's the review of one is in many ways contingent upon a review of the other
Now,
together.
26 deals with the forfeiture,
Correct.
right? And 27 deals with the judgment.
Correct.
Okay.
Exactly. This case, factually speaking, there is not a dispute in terms of what the surety did in this case. This is not a case where the surety is coming in and saying, we tried to do something, we couldn't find the person, and somebody caused us to miss the person. We hear a lot of excuses that are sometimes made in the business, and you come to the court for relief, or relief that you're not entitled to. In this case, the surety took out a Darrell Snyder on multiple charges in two counties, both within the First Circuit, charges in Escambia County and as well as charges in Santa Rosa County. And what happened was he did the surety a favor and missed both courts, missed Santa Rosa first, went on the lam, and then he went on the lam shortly thereafter in Escambia. So the surety put together a team. They successfully located him, and this is documents that are in the record that we're all, it's in our record, located him at his address in Alabama. They brought him back, and what they did is they surrendered him they could only surrender to him to one of the courts, to one of the jails, and he was surrendered to the location where the forfeiture was earlier in time, because they have the 60-day. They have to make sure they have more of a chance of making sure what has to be done is done. So they surrendered the defendant to the Santa Rosa jail, and filed the paperwork which allowed them to secure relief without a motion needing to be filed under Florida statute 903.268. You don't need a motion when there's a surrender under those circumstances, and they got it. But they also, the agents correctly did the right thing and reached out to the warrants unit at Escambia and says, make sure you put a hold, we got this guy in custody. I would submit to the court that at that stage, because we know that no motion was filed by the surety under to set aside the forfeiture. This motion is to set aside the judgment. As to why that ball was dropped, or how it happened, or why that happened, I don't have a reason.
That would have made this easy if you would have
This
sought it.
had to be done, but I can proffer the following, and you can ask Mr. Lee for clerk counsel, because I've been doing this since 1988. And the statutes change, but 903.26 feeds into sequentially 903.27. And the law is clear under all the case law that we have, including the key cases that were presented by the clerk of the court, that forfeiture judgments can only be set aside for grounds for which you had to set aside the forfeitures under 903.26. So you have to look at the grounds under 903.26 in giving you your remedy under 903.27. So the first thing we want to ask ourselves...
And that used to be more express in the law, right? And that was eliminated.
It was removed, but the sureties figured now there's no restriction. Well, there's still a restriction, so they kept that in there, and it's a limitation.
Yeah, and part of I think the difficulty for me here is that 2.7, of course, allows you to seek to set aside the judgment, and you followed the procedure, you paid, and you did it within 35 days. But then it gives no guidance as to how's that determination to be made by a court.
Correct. Because it gives no guidance, we can only look to the authority of what we've had in the past and past decisions that have been made. In the State versus American Bankers decision, that is a primary case that involved a belated surrender, which I would submit, if I could say one thing over and over again and do nothing more and sit down, I would say this is not a belated surrender. Setting that aside, it was that court that is being relied upon by appellee, by the clerk's office, that stated that even though that language is not there, surety, that's still your limitation. In this case,
But that's just another DCA sort of surmising the law, right? I mean, that's not the law.
correct. But I do not want to present to the court and assume that a court has authority to set aside a forfeiture for any reason that they want because there's no limitation provision. I would submit that the way to look at it is that the court can look to 90326, which does have a limitation provision, which says you cannot discharge a forfeiture for reasons not in the statute. So I think it's a fair adaptation since 90326 feeds into 90327. I think it's not unfair for the surety to have a limitation. And
So your argument isn't that it's just some untethered equitable reasonableness thing that's going on in 27. Actually, it's tethered to 26.
I believe so. Now, the reason I'm saying is that I could argue equitable reasons. I can argue mistake. I can argue all kinds of things. But it's not necessary to go there because we don't need to go on equitable grounds. We can go on a strict statutory grounds. That's what's very clear in this case. I would submit and can ask Mr. Lee, if Mr. Reich had submitted this motion to you, as soon as that guy got surrendered in Santa Rosa and the hold was placed, a motion to approve a motion to set aside or discharge the Escambia forfeiture before judgment within the 60 days, what would your position have been? And I can submit that he would say, no, I would stipulate to that, and the motion would have been granted.
And so do you think American Bankers helps you or hurts you?
Absolutely helps, because in American Bankers, the surety lets a case go to judgment. I believe they didn't even file a motion to set aside the judgment in time. And then after judgment, the defendant's arrested in Peru and then brought back. Now, when we look at the grounds here, we're looking at the 90326 grounds here. Under 90326, now 5B, defendant any jail or prison on or within 60-day periods. That is grounds in and of itself.
So you fall squarely within 26, whereas in American Bankers, they fell outside of 26.
They would have fallen outside even if they timely filed it and did what they had to do procedurally. But the denial of relief under the American Bankers case was not about the fact that the surety didn't file a motion before judgment. That had nothing to do with it. I'm not aware of a case which says, surety, if you have grounds but you didn't exercise them before it went to judgment, then you're deprived from filing a motion to set aside a judgment under 90327 subsection 5, especially when we know that under the general rules of forfeitures, they're not favored at law. The statutes have to be construed strictly, and we cannot add requirements by either local rules or court rulings. In other words, and that's where I think the judge was mistaken. The judge correctly noted that we complied. Surety did everything they had to do. What the legislature wants them to do, return fugitives promptly. They were pretty quick. They did their job. But they dropped the ball in filing it.
And
the court agreed.
You haven't sought remission under 2.8. This is a 2.7 case.
And that's the problem. That's the hammer that the surety has to deal with if something goes into judgment. If something goes into judgment under 90327, the surety does lose a right to seek remission under 90328. We don't even get to that point in time because the remission is there and is an incentive. When a forfeiture is paid timely, then there's a sliding scale of rewards for the surety that locates the defendant. The longer it takes, the lower it gets. Also, there's a subsection 1 under 90328 where the surety can, if there was no breach, the defendant was deceased, or other reasons there was no notice, grounds that are accumulated from other statutes, you can remit the forfeiture. But because this went to judgment, we cannot go under 90328.
Can I ask you, under this judgment, the clerk of court argues that the standard of review is an abuse of discretion when we're reviewing a trial court's decision on a motion to set aside a judgment. Do you agree with that standard of review?
No, it's not abuse of discretion. I don't know if the right word is just de novo review, and the courts, we know what the law is. We know what the facts are, but I think the application of the particular law to these facts is something the courts can take up almost, has authority to review, not for abuse of discretion, but for review just what is the correct ruling. If the court incorrectly added legislation to this, a requirement that's not in the statute, there's only two requirements to file this motion: pay the judgment timely, pay it and file your motion timely, and all the authority says your substantive grounds are based upon what existed before you went to judgment, i.e. 90326.
So is it your position then that the trial court doesn't have any discretion if those criteria are met under 2.6, then it has to set aside the judgment? There's no discretion there.
Yes, and I believe that the authority, I think it's the one remedy a surety has if something goes into judgment. There is no other remedy unless, and this is a question as to where we're at, it's not in this case, unless there's 1.540. And we're not here to discuss whether a rule of civil procedure 1.540 mistake would apply, so we're not going there. And that was withdrawn, and it's not needed at all to be dispositive. I think the court wanted to grant it, but felt somehow that there was a requirement, or agreed with the argument of clerk counsel, that because the surety didn't take action and file a motion in the lower court, they're precluded from proceeding. And I think kind of that's the reverse burden. I think the law, when you strictly interpret statutes, they almost added a third statutory condition to 903.265. Pay the forfeiture within 35 days, file your motion in 35 days, and show us that you took action to set aside the forfeiture before judgment. That's not there.
So you're saying if we can clarify the law, then then the court's discretionary call would have been different?
Well, I think that if the law states that the trial court would, if the motion had been brought under 903.26, had to grant the relief to the surety under 903.26, 5B or 5C, I believe that same holding would apply in the same standard. The surety is not asking for more than what it was entitled to. The surety is not asking less than what it's entitled to. It's a remedy for what existed before it went into judgment.
Yeah, as I understand your colleague's argument, they're saying even if you ring the bell under 2.6, you can't get 2.7. But short of that, and you're saying that if you ring the bell in 2.6, you have to. But short of that, there's this discretionary thing they may give it. So it could just be that if 2.6 is satisfied, then the court has the discretion to give. And that would be something different than it sounds like you're both are saying.
I feel that if the surety had filed the motion before judgment, the law is clear that the court would not have discretion. They would have to follow the legislative mandate. Surety did what it had to do under the statute. And as has happened over and over now, if the courts were to say, well, we're happy that you surrendered this defendant, or the defendant was back in custody in any jail, that's what the law is. So it didn't matter whether the defendant was in Santa Rosa or in Escambia. The defendant was back, especially with a hold. So the conditions were satisfied under 903.265. I believe that there would be no discretion at that time. The court would have to grant it, and I think it would be clear reversible error. And I think there are cases that go back, such as Dolly Boulding, that's a case. I think that carries over in this case.
I could see discretion coming in, because if it was the 60th day that you found this guy, or that he presented himself because he was found to be dead on the 60th day, then that would be much more sympathetic than, hey, you guys got him on the 20th day and then didn't do anything about it, and so you let this clock run and created this problem that could have been avoided.
The court is absolutely correct. It's an expensive problem, but the statute accepts that. They said, listen, you had your grounds to proceed, but if you don't pay it, it's going to go to judgment. Now, what's your penalty? Now, you can't file a motion without putting all that money up. You got to pay the money. You got to file the motion within 35 days. The money would be held in escrow. You lose your remission rights. There's a lot of problems when you let a case. They're being penalized enough. So it's not like they're doing. I can say with a great deal of confidence, handling these motions, since I received them by faxes in 1988 when I finished years as at the state attorney's office, that sureties do not want things to go to judgment. Evidenced in this case, when the surety found out, I think within 1 day or 2 days, not within 35 days, 2 days later, they paid that judgment. And a lot of, I can say, and it's not something that was an evidentiary hearing on this, heads were rolling as to why this happened. Here you go through and essentially you're risking your lives. Every day when you're surrendering people, you are essentially a law enforcement officer. When you safely arrest somebody, you go through all that difficulty. You surrender somebody. You do everything right. You notify the warrants unit. You deliver the body peacefully and safely. Do exactly what the legislature wants. But you didn't take advantage of a right that you had. So it's not that surety's not doing anything wrong. A mistake was
You're
made.
deep into your rebuttal time.
I don't
Unless there
know.
are any other questions, why don't I add 2 minutes to both sides, and we'll hear now from the appellee.
Thank you.
Thank you.
Good morning. May it please the court. Cody Lee on behalf of the Escambia County Clerk and Comptroller's Office. The text of sections 90326, 90327, and 90328 reveal that a final judgment that's entered under 90327 may not be set aside solely on grounds that the forfeiture could have been discharged under 903.265, grounds that were never presented to the trial court. The appellant below filed a motion to set aside the judgment under 90327, parenthetical 5. But the heart of the motion, what remained in front of the trial court and what remains in this record on appeal is a request to discharge the forfeiture under 90326.5. In other words, it is a relabeled, late-filed motion to discharge the forfeiture. And it was properly denied by the court because at the time it was presented to the court, it had lost jurisdiction to discharge the forfeiture. And
But couldn't that be a reason that 27 is here? To clean up the equities that first 60-day period doesn't account for. You know, the death discovered on the 60th day, the offender who is brought in on the 60th day, where the parties, the court and the parties and the clerk aren't talking to each other or couldn't have talked to each other.
Judge Osterhaus, those aren't the facts in this case, and the facts in this case are that
Sure. Okay, then why doesn't 27 give you 35 days to clean up when the discharge process was satisfied, but nobody recognized it? It seems like it is in certain cases. Like the clerk gets the benefit of it if the clerk doesn't provide notice in the right time, and if I think a 26.8 subparagraph 8 problem presents itself. You have cases that say, okay, 27 can clean up 26. Why doesn't 27 clean up 26 in this case?
Let me go straight to the text of the statutes to answer that question. And let me first start with 90326.5 and start with the phrase within 60 days. The court shall discharge a forfeiture within 60 days upon. And then following that are 4 different paragraphs upon grounds upon which a forfeiture may be discharged. But the statute is clear. The court shall discharge a forfeiture within 60 days. And so it is presenting a time limitation on that discharge of the forfeiture, and that the court can only discharge the forfeiture within 60 days. You see the within 60 days repeated in subsections.
Are they talking about 2 different 60 days? I mean, it seems like if you read this, you know, in one instance, the court shall discharge a forfeiture within 60 days upon, you know, go to C, surrender or arrest of the defendant, skip over a little bit, within 60 days of the date of the required appearance. So it seems like there could be 2 60 days that come into play that are different.
I think there are 2 60 days. I think the first 60 days is a limitation on when the court can discharge the forfeiture, and I think the second 60 days, which are repeated in A, B, C, and D, are limitations on when those events occur. And so, for that reason, to answer your question, a death on the last day, the surety under the text of the statute has 60 days to discharge the forfeiture. What I believe is an unambiguous section of the statute, and so there's risk in this, and the statutes 2.6, 2.7, and 2.8 bind this court, and so under your example, if the surety is unable to secure that order of discharge, then the statute would confine the court in doing that discharge outside or ordering the discharge outside of 60 days. In other words, using a
But then
903...
you would go to 27, and it would give you 35 days to clean it up, it would seem.
I respectfully submit that 903.27 is not a way around the limitation in 903.265. In other words, a motion to set aside a judgment cannot be simply recast or solely on grounds that a forfeiture could be discharged under 903.265.
What in the text of 27 tells me how a court is to make this decision? I understand that under the prior law, it said that 26 expressly, those are the reasons why you would grant 27. But now you're saying 27 can't be granted for purposes of 26. And where do I get that in this text?
That's an excellent question. So I think the question before this court is not what are all of the reasons that a court could set aside a judgment under 903.27. I think the only question that the court needs to answer here is whether the issue that has presented itself, in other words, the surety was entitled to a discharge of forfeiture. That's its argument, right? It was brought before the court outside the 60 days. And so I think the court needs to only answer that question. And that question is that the answer to that is that the statute limits the discharge of a forfeiture within a 60-day time frame. A 903.27 judgment cannot be based solely on those grounds.
Why not?
Because
Where do I see that?
it is not expressed in 903.27. I think it's the context of the statutory scheme as a whole. And let me continue. 903.262A. The forfeiture shall be paid within 60 days after the date the notice was mailed or electronically transmitted. So we have a 60-day time frame in 265 to discharge by order of the court. There's a 60-day time frame for payment in 2A. And then the first part of 2.7.
Are those concurrent timeframes, or could those be slightly staggered or
Judge Treadwell, the 60-day, I think the court should read the 60-day time frame as starting at the time that the forfeiture is entered by the clerk and provided to the surety in both circumstances. And I understand that 265 does not say when that 60 days starts, but I think the context of the statute as a whole answers that question.
Can we go back sort of to the statutory text? Because looking at the pre-1986 version of 2.7, where it does sort of limit the trial court to those reasons in 2.6, if this case would have been brought in 1985, would the appellant have been entitled to set aside the judgment?
At that time, the statute said upon filing the motion, the court may stay execution on the judgment or set aside the judgment in whole or in part only for those reasons of which the forfeiture could have been discharged. Yes, I would say under that from 1982 to 1986. But that's not the statute that we're dealing with. We're dealing with the absence of statutory text in 2.7.
So is your argument basically because of the revision in 1986 to that statutory language, the reasons in 2.6 can no longer support set aside under 2.7?
That's correct. The reasons in 2.6 do not survive, just like the reasons in 2.8 do not survive.
Then what are valid reasons to set aside a judgment, in your view, under 27?
That's an excellent question, Judge Norby. So failure to provide pre-forfeiture notice. So the clerk didn't provide, for example, notice to the surety of the court date. There's a couple cases, Accredited Surety and Casualty Company v. State, Bailey v. State.
That's a 2-6 requirement. That's a 2-6.
That's not a
1B requirement. So we're
That's-
back to 2-6 again.
We are, but we're not a request to discharge under 5 A, B, C, and D, which have the within 60.
But what text in 27 limits what can be the basis for a motion to set aside? Point what specific provisions and language?
In 2.7?
Yes.
There are none. And I think the court needs to look at the statute as a whole and determine what isn't, what are not grounds. I think that's the only question that this court needs to answer, because what is presented in this case is a recast motion, late file motion to discharge under 903.27. But the only basis that the surety argued, and there's no evidence of the mistake, there's no testimony, there's none of that. That's what the original motion was. None of that is in the record. And so what we have is a late file jurisdictionally barred motion to discharge the forfeiture. The same result would be if the surety filed a motion for remission under 2.8. That is confined to if there's payment within 60 days. And so just like 2.8 is unavailable to the surety, so is 2.6. And Judge
No,
Oster,
you're saying 2.6.5 only, but the rest of 2.6 is available.
those are 2.6 does many things.
Yes.
It sets out conditions precedent to the forfeiture, time limits of when things are to go out, and so those are errors of substance or procedure.
Why isn't 5 error of substance or procedure? In fact, you cite American Bankers for that substance and procedure idea, and it cites a current Judge Logue, or an old Judge Logue treatise that the parenthetical as a final judgment can be set aside only for the reasons that underlying forfeiture could be set aside. So it seems to be embracing all of 2.6 in American Banker.
I think that's a play off what the statute used to say from 82 to 86.
Well, it's an 89 treatise, but okay.
I think the court, the question before the court that needs to be answered is whether a motion to discharge, whether grounds that you can bring under a motion to discharge survive after a judgment is entered. And I would submit that the statutory text as a whole says that those are not grounds to discharge or to set aside a judgment. Let me get back to what are grounds. Again, failure to provide pre-forfeiture notice. All the clerk's discharge criteria met pre-judgment.
But where in 27 is that language?
Again, that's not in 27. There is no.
So it's very open. It doesn't speak to what the grounds are. It doesn't limit them. It doesn't set them out. But it acknowledges that you can file a motion to set aside the judgment.
That's correct.
So that's kind of your substantive right. You can come in and file a motion to set it aside, and it doesn't place limits
That's
in the
correct.
statute.
That's correct.
So,
It does not. It does not.
And the best case supporting your argument that you point to seems to be American Bankers for that idea that errors of substance or procedure are those that can be remedied in 27.
I think that's a good case, and it looks at the statutory text as a whole, and it looks at the statutory text as it exists currently. There are other cases. Frontier Insurance Company v. State finds that the court lacked jurisdiction to hear a discharge that was brought before the court 65 days after the forfeiture. County Bonding Agency v. State talks about the time frame in 903.265 not being able to be extended by the court. And so there are a number of cases that I think interpret that within 60 days to limit and to say that the court can only discharge a forfeiture within 60 days after entry.
But then you get 35 more if you file a motion to set aside.
Well, and I think that converts the 60-day time frame into a 95-day time frame, which I think is cross with what the statute is saying. I think it seems to me that the better interpretation of the statute as a whole is that if the court bases its set aside of the judgment on grounds that are not in 2.8, motion for remission, 2.6, motion for discharge, and looks at some sort of, was there an error in the run-up to the forfeiture? I think that is the better interpretation of the statute as a whole. I think that's what State for Use and Benefit of Metro-Dade County versus American Bankers looked at and found. And I would submit that the court did not, I think the standard is abuse of discretion. I would submit that the court did not abuse its discretion in making its decision.
Let me ask you, if the trial court was incorrect on the law in terms of what these 2.7 motions are limited to, did the trial court then abuse its discretion to deny the motion?
Wrong in which way?
Meaning, did it have discretion to still deny the motion even if it's incorrect on the law?
I think it would. I think it would have the opportunity to look at what's been presented to the court at that time and make a judgment call on whether the motion under 2.7 should be granted.
Were there any facts in dispute that it would need to make any factual findings as part of that judgment?
There were allegations of a mistake in the original motion, which the clerk sought discovery on. That was objected to, and so those facts are not in the record.
So what grounds would the trial court have had to deny the motion if its legal conclusion was incorrect?
What grounds would the trial court have to deny the motion? The grounds that it had to deny the motion was that the motion to set aside the judgment under 2.7.5 is nothing more than a late filed motion to discharge the forfeiture under 903.265. And that's confined by the within 60 days limitation. If the surety had presented some sort of other, there was procedural irregularity, the defendant was there, court didn't know, an error in the record would be a basis to set aside the judgment. If there's no further questions, my time has expired. Thank you.
Thank you, Mr. Lee. Mr. Reich?
Thank you. There are 2 points that I want to make. I believe Mr. Lee is saying that the only grounds that the court would have to set aside a judgment when a motion is timely filed, as was done here, is if it's a clerk error or court error. And although there's language to that, all of those cases where there was no notice to the surety under 903.261B or post-forfeiture notice, another provision, they have to provide post-forfeiture notice under 903.262A. Those are clerk's error. But the relief was not granted under 903.2.7 because of clerk's error. It was granted because there was failure to comply with 903.2.6. So the court was looking to the 903.2.6 in its remedy under 903.2.7. So in other words, it's what's good for them, but it's not good for the surety. And that's, I think, that's a problem to take that position, and that's a mistake by the clerk's office when they do that, and both sides can make mistakes also. I'm worried about a scenario that didn't arise in this case, but it easily could have. I know I mentioned when I first started doing these motions, I would receive them by fax usually. It doesn't have to be printed out, it's there. But often you do get an attorney request or to staff that would have a PDF with pages and would have forfeitures in 2 counties. And you got to be real careful because the surety is doing their job. In this case, they did their job. They did it really, really good. Truly justice was served. They do their job, and if they had provided this to me, let's say, which they should have, and I would look through the forfeitures. I'd say, okay, Santa Rosa, you don't have to. You're fine. And then I miss it. And I miss this can my fault. Attorney error or mistakes in all kinds of professions and reviews by the courts, they look at that and allow for that type of leeway, whether it's 1.540 or not 1.540. And
Thank you, Mr. Wright. Your time has expired. If you want to briefly conclude.
Thank you very much, and for the additional time, I definitely am concluded. It's a pleasure. Thank you.
Thank you.
Thank you.
Thanks, both of you. That was very helpful. This is the only case on our docket, so we're adjourned. Thanks.
All rise.